This court hereby orders Willow Tate to hand over and/or divulge all relevant information regarding the child she gave up for adoption to the plaintiff.
Your Honor, I object. My client cannot be coerced into divulging anything.
And why is that, Miss Miller?
Because any documentation provided by the plaintiff was obtained in violation of HIPAA and is therefore fruit of a poisonous tree. Nardone versus the United States, Your Honor, 1939. Any evidence obtained illegally is inadmissible.
And how do you see that precedent applying here?
Well, the plaintiff alleges that my client gave birth to a healthy baby boy sometime in July of last year, but those records, if they even exist, are protected under HIPAA, and therefore, no one is allowed to access them without the express permission of my client. So any records divulged to the court by the plaintiff were obtained in violation of that law, and therefore this entire proceeding is invalid. Motion to dismiss.
Objection. The welfare of the child takes precedence, Your Honor. Valentini v. Van in 2008.
That precedent does not apply.
And why not?
Because the case cited by the plaintiff's attorney regarded a child in imminent physical danger. In this current circumstance, there's a mountain of legal precedent resulting in numerous Supreme Court decisions, all saying exactly the same thing. Fruit of a poisonous tree is inadmissible. This case must be dismissed.
If there's even the slightest chance that this child is in jeopardy, imminent or otherwise, we are going to proceed. I hereby order the defendant to turn over any and all information with regards to her child.
Okay, look.
Your Honor, with all due respect, what is happening here is a blatant violation of my client's rights, and I am going to instruct her not to answer any questions.
She can't be forced to answer questions, but you can. Buchanan v. Lord, 2002. If an attorney's actions directly affect the case, then she can be compelled to answer.
Are you kidding me? That was a real estate transaction. You can hardly compare the two.
Ms. Miller.
Look, this entire proceeding is subject to appeal.
And you are well within your rights to go down that path. However, today we are in my courtroom, and today you are going to answer my questions. Ms. Miller, did you or did you not represent Ms. Tate with regards to a child born to her?
That falls under attorney-client privilege, Your Honor, and I'm not going to answer.
Then you will be cited for contempt and placed under arrest.
Diane. Okay, well, since I'm obviously going to jail, let me just say that unlike you, Your Honor, I know my client's rights, and I will continue to fight for them no matter what obstacles or bogus precedents are thrown my way.
Then I guess we'll just have to let the chips fall where they may. Bailiff, please escort Mr.
Your
Miller.
Honor, that won't be necessary. You want me to say it? Fine, I'll say it. I had a baby, and you will never find him.